Be ready. 5 seconds. Under the statutes like PMLA, the minimum sentence is 3 years, and the maximum is 7 years. Stop. The minimum sentence is higher when the scheduled offense is under the NDPS Act. Stop. When the trial of the complaint under PMLA is likely to prolong beyond reasonable limits, the constitutional courts will have to consider exercising their powers to grant bail. Stop. The reason is that Section 45 does not confer power on the state to detain an accused for an unreasonably long time. Stop. Someday, the courts, especially the constitutional courts, will have to take a call on a peculiar situation that arises in our justice delivery system. Stop. There are cases where clean acquittal is granted by the criminal courts to the accused after very long incarceration as an under trial. Stop. When we say clean acquittal, we are excluding the cases where the witnesses have turned hostile or there is a bona fide defective investigation. Stop. In such cases of clean acquittal, crucial years in the life of the accused are lost. Stop. In a given case, it may amount to violation of rights of the accused under Article 21 of the Constitution, which may give rise to a claim for compensation. Stop. As stated earlier, the appellant has been incarcerated for 15 months or more for the offense punishable under the PMLA. Stop. In the facts of the case, the trial of the scheduled offences and, consequently, the PMLA offence is not likely to be completed in 3 to 4 years or even more. Stop. If the appellant's detention is continued, it will amount to an infringement of his fundamental right under Article 21 of the Constitution of India of speedy trial. Stop. The decisions the learned S.G. relied upon indicate that the appellant's influential position in the state may have resulted in a compromise between the bribe givers and the bribe takers. Stop. Considering the apprehension of the appellant tampering with the evidence, stringent conditions must be imposed. Stop. Therefore, the appeal is allowed, and the appellant shall be enlarged on bail till the final disposal of CC number 9 of 2023 pending before the principal session judge, Chennai, on the following conditions: para. The appellant shall not directly or indirectly attempt to contact or communicate with the prosecution witnesses and victims of the 3 scheduled offences in any manner. Stop. If it is found that the appellant directly or indirectly made even an attempt to contact any prosecution witness or victim in the scheduled as well as offences under the PMLA, it will be a ground to cancel the bail granted to the appellant, para. The appellant shall mark his attendance every Monday and Friday between 11 a.m. and 12 noon in the office of the Deputy Director, the Directorate of Enforcement at Chennai. Stop. He shall also appear on the first Saturday of every calendar month before the investigating officers of the three scheduled offences, semicolon para. Before the appellant is enlarged on bail, comma, he shall surrender his passport to the special court under the PMLA at Chennai, semicolon para. The appellant shall regularly and punctually remain present before the courts dealing with scheduled offences as well as the special court and shall cooperate with the courts for early disposal of cases, semicolon, and para. If the appellant seeks adjournments on non existing or frivolous grounds or creates hurdles in the early disposal of the cases mentioned above, comma, the bail granted to him shall be liable to be cancelled. Stop.